want to get that transmitter figured out.
Okay, if you guys are in the foyer, could you guys please come in? We'll get our next session going on, which is legal part 2.
You've worn us out. We're taking a seat.
Now they're sitting down, so we warned them out.
And come closer. Come closer.
I know. They're always in the back. So I am holding a orange sheet, and unlike other conferences, we actually want to hear your feedback. And that's why on the listserver we pose questions. Hey, what kind of sessions do you want to see at the conferences? And so we have this for you, and the ladies will hand them out to you. And when you're, could you just give us a couple of comments, or for next year in Kansas City, what sessions did we not? And everybody realized that we can't hit every topic, right? But if there are some things that you weren't addressed and you'd like to see addressed next time, please fill that out and put that at the registration desk. Dina and Jessica will take those for us. So, legal part 2, and we'll be able to get into more questions and more broad topics on this session.
So, we're back, and we are going to start by talking a little bit about underwriting, because this is a topic that can be confusing, and because we draw a large number of questions on it, and we are willing to answer any questions you got, so feel free to interrupt us anywhere along the way. And then if we have time at the end and we have any interest, we can talk a little bit about the FM translator interference rules and the proposed changes to those rules that the FCC is currently considering.
And we've gotten, we'll also, if we have time, to be talking about using an IBOC channel and whether that can happen. What are some of the ownership restrictions, both for full powers, which are for the non-commercials, there aren't many, and for low power FMs. So,
and also, if we have a little bit of time, we'll give just a little kind of high level overview on music licensing and the obligations related to your stations.
but mostly we want to hear what you guys have.
Since the new ruling that came out, right, with Trump and the Trump administration and the new music.
I got to be honest, the Music Modernization Act really doesn't have much effect on us.
Good.
Yeah, I mean, unless some of you are recording artists or record producers. So lay on.
I'm gonna let you go ahead, because we're talking.
So the root of the restrictions on underwriting are found in Section 399B of the Communications Act. And fundamentally it says you can't take money to run an advertisement for a for-profit enterprise. You can't take money for broadcasting an announcement for a political candidate. And you can't take money for broadcasting the viewpoint of any person with respect to a matter of public interest or importance. An incredibly broad issue. It is, I personally think, constitutionally suspect, but it's also not an area that the FCC is on this third one, that the FCC has done much enforcement action. Where the enforcement action comes in is the garden variety underwriting for-profit businesses. What the language, what you're allowed to do, you're allowed to identify the for-profit operators that are underwriting your station, but you cannot use comparative language or promotional language. Those are the broad categories, and then we get down into the minutia of what constitutes promotional language, what constitutes comparative language. For instance, and some of the rules are or the rulings are hard to follow. For instance, it's fine to say that a particular car dealership has been in your community since 1937, but it's prohibited to say that they're the oldest car dealership in your community, because oldest is comparative and 1937 is just a factual identification. Is there any realistic difference between those two? No, but it's one of the rules that come up.
It's all about the words.
It's all about the words. It's what you say on the air. And I will say that most of the underwriting issues that we counter, well, what can we do on our website? You can do anything you want on your website. What you have to do on the air is strictly adhere to the commission's requirements with respect to underwriting announcements. The price information is prohibited, and price information includes, strangely enough, free. You can run into problems by saying that such and such is available for free. You don't run into a problem by saying that information is available at a particular website or from a particular telephone number. You can identify who the underwriter is, and you can identify the business they're in, and you can use their slogan as long as the slogan itself is not promotional. It gets real fuzzy about what's a promotional slogan and what's not. Better living through chemistry was, of course, the slogan for DuPont for many years. And my recollection is the FCC said, well, no, that's not promotional. The envelope as what is permissible for underwriting announcements is being pushed all the time. The commission staff, I have to say, the commission staff picks on the little guys, because the little guys are sometimes not as sophisticated in their copywriting as the NPR stations, which go through a vetting process and debate about whether something qualifies as a proper underwriting announcement or not. I wind up reviewing copy for a lot of Christian stations and also for a fair number of NPR stations to go through the specific language and whether or not a particular turn of phrase is permissible or not. You got to get down to that detail. But I will say to you, the more it sounds promotional, the more likely it's going to draw a complaint. Where's that complaint going to come from? That complaint is going to come from, not from a listener, or at least I've not encountered that. It comes from a commercial competitor that is irritated that you're taking, in their mind, some of the advertising revenue from the market and converting it to themselves. Now let me, before there's a whole array of areas that we could go off on to, but one of the ones that I want to point out is to make sure you're aware that, as I described Section 399B of the Act, which by the way is also replicated in the Commission's rules, it's accepting remuneration for an advertisement for a for-profit company. If it's not a for-profit company, if it's a nonprofit, you can do what you want. You can give price information. You can say tickets are available here. You can say what a great concert it is, if it is truly run by a nonprofit. Now, when you have these combinations where it's sort of a for-profit promotion concert, but there's a nonprofit involved, then you have to do a closer analysis. But if it's really straightforward that the underwriter is a nonprofit, your hands are free. You can do what you need to do. The classic example in Washington, D.C., although strangely enough they haven't taken advantage of it, is the National Symphony Orchestra is a nonprofit. And therefore, it could advertise its ticket prices on non-commercial stations if they chose. By happenstance, they don't. Tell me what I've skipped over.
Actually, there's lots of stuff you've skipped over, but one thing that's been, this is an area that is just huge. I mean, there are so many permutations, and it's all about the words. One of the things that I was going to raise was fundraising, fundraising for third parties. Generally, fundraising by non-commercials is prohibited, but the FCC has adopted a limited exception for nonprofits doing on-air fundraising for other nonprofits. That is now considered acceptable.
Right. You can do up to 1% of your airtime for it. Now, let's be clear about what this is. This is interruption of regular programming. This is doing a marathon for some other charity or organization. You can do a marathon for another organization, but it is limited to 1% of your annual airtime that you can do that. And I'm trying to remember, I think it works out to be 3 days that you could do, but I think that's right. And that's in the aggregate. I mean, so if you wanted to do 3 days for one, that'd be fine. If you wanted to do 3 one-day solicitations, that would be okay too. You have to keep track, you have to make note of what you've done in your public inspection file. If you're interested in that, and there's a few more details, let us know, and we'll provide you some background on that. The prohibition does not extend on third-party fundraising, or the limitation doesn't extend to announcements that do not interrupt your airtime. So if you're just running a 30-second or a 15-second underwriting announcement saying give to the Red Cross or give to such and such an organization, that's okay. That doesn't count towards your 1%.
The one other thing that I would mention that we didn't specifically touch on is calls to action, which is just another character of the underwriting announcements that you do. The FCC prohibits calls to action, so you can't say, next time you're in the area, go to, or next time, you're at this shop, buy. And that's very simplistic, but calls to action are specifically prohibited. Again, it's all about the words. It's all about how you present the announcement that will determine whether or not it's prohibited. Different words can...
Let me mention that we have, I think, a snappy little memo which outlines for license stations the restrictions that the FCC has. If you send us an email, we will send you the memo. We could actually send you one of 2 memos. The one memo is readable because it's not festooned with footnotes. The other one is basically the same memo, but it does have all the footnotes and has all the cases cited that we, in our office, we call it our internal version because we can track down the case where a particular ruling was made. Like I say, sometimes those rulings don't necessarily, when one's compared to another, make much sense, but we can follow them. When we're confronted with a problem that we don't know immediately, we go to the books. We go to, well, it's actually online now, but we go online and we look at what the commission has said and see if we can identify some of the issues that come up. One of the issues that came up recently had the United, or the Cesar Chavez Foundation, or their United Farm Workers stations got a substantial fine recently for some of their underwriting announcements. And it had to do, one of the issues that came up was what is called the menu. Now, you're allowed to list the goods and services that a particular underwriter offers, but you can't put a quote-unquote menu. Now, what is a menu? The commission has never explicitly said. We used to have a rule of thumb, if it was 7, you couldn't do it. Then in the United Farm Worker case, they cited one for 5. And so we're now telling people, stick to 3. So if you say Bill's Auto Shop can do bumpers, headliners, and seats, stick to that. Don't add in that they also can do paint jobs and change your tires. So let's, if we could, if people have questions about underwriting, please let us know.
You don't.
I think, hello? What is this, orange? Orange. I think you touched on this, but for clarity, I know we've talked about this before. I think I emailed Bill about this. Concerts in particular, I was contacted by a promoter to do a concert, and I said, well, I'm a non-com, and they said, oh, well, we can go through our nonprofit. And so there's a nonprofit that they apparently operate or that's connected with them. And, you know, the thing is, who's bearing the burden of, I'll let you talk because you can explain it, but it's about who's got the risk for the event. Is that how it goes? I mean, you know, because it seemed a little sketchy to me.
Well, okay,
So,
there's
anyway.
a couple of different ways to deal with that, the concert promotion. Now, I hadn't encountered one where somebody said, oh, well, we have this nonprofit just sitting here on the, it seems a little shaky to me, but if it truly was a bona fide nonprofit, then you'd have a free hand. You know, then you'd have a free hand, you could put ticket prices, you could do everything else that you wanted for those announcements. If, on the other hand, you came to the conclusion that either that was not a bona fide nonprofit, or they said, no, we're a for-profit organization, you still can run announcements, you still can take underwriting, but it has to follow the usual underwriting rules. It has to follow the usual rule that you don't identify, there's no price information, there's no calls to action, there's no comparative language. You can't say, oh, these fabulous musicians. You can't say that. You'd say, this group will be, this group, not identifying if they're good, bad, or indifferent, will be appearing at Meriwether Post Pavilion at August 4th at 8 p.m. For more information, go to blah, 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 blah. I would be apprehensive to say for ticket information, I wouldn't say it, but I'd say more information, you could do that. One of the issues that comes up and that you're referring to is what if you want to identify as a producer or a sponsor? When you get into that, where you're lending your name to the event as a nominal sponsor, and if you're going to do that, you have to have, to use the vernacular, skin in the game. If you're going to be a promoter of a concert, it has to be true. Because you are allowed to have station events where you promote use a musical act to promote the station, to promote underwriting, to promote support. But it really has to be bona fide, and you have to have some risk, that risk of failure, if you're going to be identified as a co-sponsor.
Same kind of thing arises with stations that sponsor trips, like a trip to Israel. Use that as an example. If you are relying on a for-profit travel agency to set up and sell the tickets and all, you might have problems. On the other hand, if you, as a sponsor of the trip, you buy 6 spots, and you're taking the risk then, you're on the line for those 6 spots, then you actually have the skin in the game.
Right.
But you still have to be a little bit careful about how you direct everybody to the for-profit travel agency. If you have a nonprofit travel agency, then you're dealing with a different thing. But if you're dealing with a for-profit travel agency, you have to have some skin in the game, and you have to be careful how you direct people on.
When Kathleen said spots, she meant
I'm sorry.
places on the boat rather than...
Right, places on the boat or on the
announcement.
plane or
Right,
on the
right.
bus or whatever.
Just quick follow-up clarity. So then for like a concert, would the nonprofit have to have the full risk or partial risk or skin in the game for that particular event?
Yes. If they were sponsoring the concert, they'd have to be the one that took the risk that nobody showed up.
The full risk or partial?
Hard to say. I mean, there's a question of where it gets so far down the line that it's no longer bona fide.
Yeah, that's
You know.
and I was, anyway, that was
Right.
the kind of thing I was like, anyway.
Well, that's exactly right. Now, again, if you're just running announcements and they're just garden variety
Well, no,
announcements,
this was going to be, produced spots, the traditional concerts.
right, right, right. By the way, just so you know, the FCC has never created a standard as to how long an underwriting spot has to be or can be, but they have said explicitly that the longer it is, the more likely they believe that it will be impermissibly promotional. So if things get longer than 30 seconds and a complaint is filed, that's going to be a starting point of the raised eyebrow and maybe a closer examination. And these are, the commission is enforcing the underwriting restrictions with respect to normal underwriting spots. I mean, we are encountering that. We are seeing significant, or at least significant fines.
Yeah.
Where people are having, and then people are winding up having to enter into consent decrees. Let me explain what that is briefly. If someone is cited for violating the underwriting rules, the commission typically will come back to you and say, well, rather than us coming through and issuing a notice of apparent liability and dragging out this process, how about you enter into a consent decree? And the consent decree basically is an agreement between the FCC and the station under which the station agrees that for a period of time it will go through some extraordinary monitoring process. When I say that more than normal monitoring process, and that they will agree to do compliance review, and that they will agree to do training, and that they also will agree to pay a fine or a forfeiture. Those are typically the way the commission resolves these cases now. It's kind of a disadvantage to us because in those consent decrees, they rarely discuss what the actual violation was. So we don't have any more background information about what caused the FCC to conclude that the spot in question or spots were promotional.
Yeah, I believe all of us air 26-minute spots, programs. David Jeremiah, Sandy Adams, Greg Laurie, all are ending a lot of their programs with promotions to Israel. They speak of quality, and they are through a for-profit travel agency. So what do we do?
That's wonderful. Good question.
So do we know what, in this particular, do we know that the ministry that's mentioning these things presumably is a nonprofit ministry? And we can probably presume that they are taking the risk, that no one will come on the cruise, and that therefore they will have, would have suffered a loss if no one came. Now they know that there's a lot of ways to mitigate that risk. You only buy a few seats or a few cabins the first time around, and then you just add people as it goes along. So more than likely, that's going to be fine. And it has not been an area, strange, that where the commission has come out and tried to do any enforcement action. Okay?
Earlier you mentioned something about a website, you can do whatever you want.
Pretty much.
Would that include in an underwriting spot saying for more information on Giuseppe's Pizza, see the Calvary or Crosswave Radio website? Would that be legal? And then to have whatever information you wanted to give as far as pricing or whatever on the website, or for example, a Facebook page?
Well, yeah, you've done a nice job of making it as cloudy as we could and making it, but my opinion is that that would be perfectly permissible.
Yeah.
That what we got, what the commission has no, with very limited exceptions, the commission doesn't have any authority over your website.
Right.
If you were running children's television programming, that wouldn't apply, but
I guess my question is if I send people to my website to see more information about that company, is that a call to action?
No, well, the commission has not deemed for more information, see this website as a call to action. I mean, obviously, in the plain words of it, it is a call to action, a call to go to a website, but thus far, the commission has not cited anybody, has not deemed that a call to action.
Just one quick comment on that. So you would not want to reference a specific aspect of that website that might have, like if you wanted to stay way above and beyond, like don't even get close to where the line is, only mention the website itself. Don't drive them to a page or a point or a specific aspect of the site that's going to be promotional or commercial. That would be my only comment.
That would be the safe approach to follow.
So once again, the FCC doesn't have the authority to regulate your website or, which we have talked about in previous years, your live streaming. It's different than the on-air, am I correct?
Correct.
So
Correct.
did you get that? So a lot of guys have split their live streaming up, and they can put whatever they want on their live streaming. That's going all over the country or all over the world. It's just what's on air.
Correct.
Regarding underwriters, because we have an underwriter who does like cybersecurity, and they've asked, and they're very interesting. So it's an interesting topic. Are they allowed to be interviewed if they're underwriting? Like, does that then cross the line that it's?
I mean,
promoting
having them
them.
on your air sort of as a
Yeah, like
PSA or
somebody-
an issue of interest to your listeners?
Somebody heard their underwriting spot and then also said, oh, and they know them, and they said, you should have them come on and just talk about cybersecurity in general, just as a guest.
So they're not paying you?
No. Well, they're paying,
I mean-
they are paying for an underwriting spot. It's like a 30-second spot.
Right, but the interview is not, you've invited them to join you to talk about a
I
topic
haven't
that's of
invited
interest.
them.
But
Yeah,
the
because I wanted to
proposal
find
would
out if
be, the
it's-
scenario would be that you have invited them to come and talk on your air about an issue that would be of interest to your listeners.
Right.
That's unpaid.
It's close, and it depends, once again, what goes out on the air. If I were to do that, I would say to the guest, you can't talk about your business. You can't promote your business. If you can talk generically about cybersecurity, that's going to be okay. I mean, you could identify who they are, what their business is, but you can't talk about, well, we would do this and we would do that, and here's the type of thing that our company would do for you. Then it becomes clearly promotional, but and there would, even though you weren't being paid for that interview, you were being paid for the other underwriting announcements, and there would be a higher level of skepticism on the commission's part that it was a bona fide underwriting announcement and not a promotional announcement. So you would have to be really confident that the person that you were interviewing was not going to promote their own business, but would talk generically about cybersecurity. In that instance, if I was doing it, I would record it ahead of time and be on the watch for that and maybe do a little editing if I had to.
What about if you're interviewing someone who has a book and then they mention where their book is on Amazon, or an artist who says their songs are on iTunes in the interview? Is that okay?
I think it's probably okay, because it's just identifying where the outlet is. It's probably okay. I
Well,
can't
kind of a
recall-
fleeting mention as opposed to making it
Yeah, I mean,
a
and
substantive discussion.
let me, not okay. It's on iTunes and it's $11.95 and it's a special this week. You can get it 99 cents a cut. Not permitted. It's on we're on all the usual distribution points. We're on iTunes, we're on Barnes and Noble, I guess,
Yeah.
still, and iTunes, and you can find our album there. Actually, I would like it, they wouldn't say you can find our album there, just say it's there. Fleeting things are probably going to be okay. Not download it now or come get it. Indeed, even if they had it on their own website and said download it for free, I'd have to think a long time about whether that would be okay, because like I say, free is price information, and price information is a trigger for the FCC.
I believe you've already addressed this question, but I do want to clarify because it's come up multiple times as we're writing copy for underwriting announcements regarding call to action. The debate has come up, call Joe's Plumbing at 814, et cetera, or go to www. Now, one of us, on the station staff, one of us is looking at that as, okay, that's a call to action, as opposed to more information can be found at www, or Joe's Plumbing can be reached at 814-555, et cetera.
I would very much prefer that you chose the latter approach,
Right.
particularly with telephone numbers. Because it's a little, like I say, we haven't had a ruling yet that I've seen, and Kathleen, if I'm...
I agree.
Ruling yet on websites. I can't say that I've seen a ruling on call such and such a number, but boy, it sure sounds like a call to action. You certainly are permitted to give the telephone number. You are certainly permitted to give the address of the underwriter. You just need to stay away from that call to action. Just tell them what it is, and boy, if they think that they like this guy because they're supporting your stations and your ministry, that they'll take it on themselves to dial that phone number. Or website. Yes.
So going back to that whole menu thing you were talking about earlier,
Right.
and kind of having the 3 as a rule of thumb, I'm assuming that applies to like one particular spot?
Correct.
Rather than over several spots. So for example, using that like auto body detail thing that you used earlier, you could be like, they do seats and bumpers and, paint in one, and then say like, and they also offer tires and stuff like that in another. So
That's exactly what
Okay.
we've done with various underwriting spots where they wanted to highlight, the underwriter wanted to highlight all their products. You broke it into several different spots.
So I may have already made this mistake, but so I don't make it again. So if we happen to be at a for-profit store, right, a dollar store,
Right.
and we tell people to come see us at the store, did I break any rules?
It's the most difficult one we have.
Okay.
Because it's right on the line.
Okay.
And we frequently ran into the problem with for-profit bookstores. I hadn't encountered a dollar store, but the same principle applies. And all I would say is that if you do that, you are permitted to promote the station. And you can come down for people to see you. You have to be very careful in that copy that you read on the air that you're not promoting the bookstore or the general tire or the dollar store. That you're just saying, come down and see us, we're at the dollar store parking lot. Rather than, oh, by the way, the dollar store is open from 10 to 4 and has great deals on Tide. So.
Okay, so I want to give you more time for broader questions.
Great.
And any more underwriting questions, please see them after the session. So let's go broader. Any other legal questions? Us not underwriting now. Let's go somewhere else because
You're tired of it.
My brain hurts.
So this is a kind of broader question that I've always been kind of concerned with on our station in particular. So like the way that we kind of do it is like we have people who essentially come in and host certain days, and like we'll come in and we'll have some topic we're talking about throughout the day and kind of have like, I don't know, maybe 20 spots, something like that. I'm just throwing out a number, but I'll pull stuff from like articles online and things like that I'll then talk about on the air. I mean, generally speaking, I won't like be verbatim reading the article or anything like that. And in any case where I do like actually quote someone, I'll like reference where it's coming from and who they are and things like that. But I was just wondering if there's any kind of legal concerns around that. Like if, for example, for whatever weird reason, this one particular person happened to be listening to our station and heard stuff that they're like, I'm pretty sure I wrote something like that, and we're like, I don't like them using that. Would we be able to, like, would we end up getting in any trouble for using something like that?
The answer is maybe. Generally speaking, The answer is no. If you are not quoting something, if you are quoting something and you attribute it, then I think you're probably fine. But if you are summarizing someone's basic concept from an article that you read and you say, I read this article from this magazine or newspaper or whatever, discussing this issue, and you give a synopsis, then I think you're probably fine. Again, it's all very fact-driven, but generally speaking, I think you're fine. As long as you identify where you read and what you're quoting from specifically, then I think you're probably fine.
But this discussion of, basically, we're talking about a copyright issue.
Exactly.
And gives me an opportunity to hit one thing that I want to make sure that you do, because it's a big thing in the commercial industry, commercial radio industry, and that is your website photographs. If you have a photograph on your website, you better make sure you have the right to use that photograph. Either that you took it, or someone who's given you permission to use it took it, or you've got it from a Creative Commons site or a Commons site. You can't just go grab some photograph. Let's say it's a contemporary Christian musician and you see them on another's website and you take a photograph and you put it into your website. You are inviting a lawsuit. And there's a particular law firm in Long Island that has made I would say a cottage industry, but it's more than a cottage. It's a mansion industry at this point of going after radio stations for unauthorized use of copyrighted photographs. So that's, I got to tell you, that's something that's come up a lot. If you want to put a photograph on your site, make sure you've had it. I'll tell you one quick story. I had a client, a Christian broadcaster, that had the most generic picture of all time, I think, of someone putting a golf ball into a hole. And they used it on their site. I mean, it was, Getty Images came back and said, that's our really boring picture of a golf ball going into a golf hole, and you're going to have to pay us a license fee that ran into 4 figures for that dumb little picture. So you want to make sure you have your rights. Okay, well, off of that, on to.
I had a question about the emergency broadcasting. We have a Sage in the studio, just one. But we simulcast 2 stations. So the printouts that we will print out this thing, and we keep a log of all that, but it only mentions one of the stations, call letters. But do we have to have 2? Do we have to do it for both, or it's just good for one?
You can handle
it. Yeah, you're clearly permitted, assuming the stations are owned by the same organization. You are clearly permitted to use one EAS unit. What you should do is in the second log, you should include the printouts and make a notation that it was simulcasting. Some notation, just the fact that the printout doesn't have both call letters, that's not going to be a problem. You might check with Sage, and if you can see if you can add a second call letter, set of call letters, but you'll be fine. You do not need a second unit.
And I had a question about donor lists.
Okay.
On the public file.
Right.
And we list all of the programming that would give us money to be on airtime, and we also list underwriters. Is that what goes on the donor list?
If the underwriter gave money for a specific program, then they need to be in that donor list. If the underwriter just gave money to the general support of the station, they don't need to be on the donor list.
What about the programs themselves?
I believe that the program should be listed because they're giving you support for running that particular program, and they should be listed.
I agree.
I've often been curious, does the FCC cut breaks to LPFM stations for violations of underwriting rules?
No.
Not at all. So we can
I won't say not at all, but
I mean,
there's no particular policy.
But I mean,
there is a policy for college radio stations run by students. There's a one bite at the apple rule for them, but not for LPFM.
I meant in particular the dollar amount of the fine.
The answer is the FCC will listen to arguments that that the proposed fine is onerous and might put you out of business.
Right.
But as a general rule, no.
And what could we expect? Range of fines first time?
$1,000 per spot. Not per airing, but per violative spot. It'll go up because it's an aggregating factor. Go up.
Could you clarify what qualifies as permission to use a photograph, something on the website? You mentioned earlier, Getty's a huge organization going after.
Right.
Yeah, so could you clarify what
Well,
qualifies?
You can get licenses from Getty and such. I'm not an expert on what those cost. You can go to them. You certainly can get a license for a single photograph, or you can get a subscription license, I believe, from Getty, but most of the time those are expensive. What commonly people do is they go to a place called one of the Creative Commons sites that offers photographs for free, usually in exchange for attribution, and that you can that you just acknowledge who the photographer is.
Right, and one follow-up. So would an email from the artist photographer, would that qualify
That'd be fine.
as permission? Okay, great.
So one of the things, if you don't mind, that Bob Moore asked me to hit on is the possibility of using IBOC, in-band on channel, an HD channel to feed a translator. And I will cover that, just to go, for some of you that aren't involved with it. A station, a programmer, could be an LPFM programmer, could be a full power programmer, goes to another station and says, I would like to, and we're going to put air quotes around this, lease, actually you're time brokering their HD channel. And you put your programming on the HD channel and then use that HD signal to feed translators. It is permissible. That although you wouldn't be able to necessarily find that in the commission's rules, and we had, I was involved in a case where the staff initially disputed it being permissible. Let me get it, because there's a rule in the 800 section, 73-800, or where the LPFM rules are there. There's a rule that's very loosely written that basically says that a LPFM licensee cannot have a time brokerage agreement with a full power station. And that's basically what it said. After we challenged it and said, well, no, this rule, the intent of this rule was that the full power station couldn't buy the time of the LPFM station. And that is clear. The full power can't buy the LPFM station's time. But it really wasn't intended to go the other way, to prevent the LPFM station from buying time on a full power station, which is what you're doing with an HD3, right. HD2, HD3 arrangement. We initially got a ruling or an informal indication from the commission, the audio division staff, that no, the rule covers that, you can't do it. My client wasn't going to take no for an answer and went to their congressman and basically said, what gives? The congressman followed the usual route that they notified the Legislative Affairs Office, the FCC, which went to the chairman's office, which went down to the audio division. And sure enough, I got a call from the chief of the audio division saying, no. I don't know why they didn't ask me. That's perfectly fine. So that is a way that people are expanding their service area by making an arrangement with a full power station to use one of their HD channels, and then using those, since there's about 6 people that have HD radios, maybe a few more, but using using that HD signal to then in turn feed translators, analog translators. Doable. There's a lot of tricks of the trade in there. So if you're thinking about doing that, make sure you consult with counsel. Kathleen and I have been down this road before, but there's tricks that can trip you up if you don't make the arrangement in the correct way. So what else, are we out of
Okay,
time?
one brief item on that is that
1
the
minute.
translator that's receiving the HD signal is a fill-in translator, and therefore can run up to 250 watts at any elevation, which makes it potentially a huge station.
As long
Also,
as long as the
it doesn't
60
interfere with anything else,
Right.
which is arguable if you're in New York City, but is not a big problem if you're in rural Virginia.
Right. Just one caveat to Bob's remark there. The 60 dBu, to be a fill-in translator, the 60 dBu contour of the FM translator must be within the 60 dBu contour of the full power station. The analog 60 dBu contour, by the way, of the full power station, in order to be a fill-in translator.
We're Class A, so if it's a Class
Well,
B,
if it's a
then
B,
big.
that's correct. If it was a B or B1, there's a different, it could be within their primary, whatever their primary
Primary
contour is.
source contour.
Class A or Class A or Class C.
Pick your HD station to be a Class B or a Class C.
Right. So it's 11 o'clock. I believe the next session is about to start.
Yeah, you have 15 more minutes.
Oh, we have
Oh,
15?
we do?
Oh, well, we can go on
You have
forever.
15
Really?
yeah.
Let me
No,
tell you about my grandchildren.
Maybe that was the wrong thing to say. Hold on.
Dusty? One of the things in media and that we have to worry about, especially if anybody has any news, is defamation liable. I didn't know if you were going to touch on that at all.
We can.
That's very important if you, as far as your FCC license is concerned.
Not as, the FCC, frankly, doesn't care about
Okay.
defamation or libel. Who cares is your supporters and your, hopefully, insurance company to make that. The FCC does not take cognizance of a defamation case. The FCC will take cognizance of criminal violations. There essentially is no criminal violation for defamation.
Right.
But a defamation case can cost you a lot of money. And if you have a lively talk programming, that particularly a live programming that's live, you need to get insurance. It's the only responsible thing is to get defamation insurance, because it can come up. And make sure when you're, I'm not an insurance expert, but make sure that it covers your defense expenses. There will be an exclusionary period, in other words, a deductible, and that deductible may be may be high, maybe $25,000, but you can hit $25,000 of legal expenses in a defamation case right away, and you want them to, you want the insurance company to be on the hook for that defamation expense as soon as you can. As soon as you, basically, depending on how much insurance you can afford. You want the exclusionary amount, the deductible to be lower, but you're going to find that that's going to have a significant difference on what you pay for it. I will mention also, defamation laws vary widely from state to state. I'm from Oregon originally. Oregon has a very unusual defamation law where basically before somebody can bring a defamation action, they have to go to the publisher of the defaming article and ask them to retract it. And that's unusual. That's not typically a requirement in other state laws. But you're going to want to get, if someone ever alleges defamation against you, you want to get your local lawyer involved right away. Okay?
Okay.
So you mentioned about the copyrights for pictures that we would post on the website itself, that, you know, we shouldn't do that. But what about the stuff that we find on our Facebook pages, things that we've screenshotted and put on Facebook? Are those okay, or should we stay away from that as well?
I would tell you it's risky, because of course you don't know whether or not something on Facebook was used properly. That the person who posted on Facebook had the right to use that photograph. That one really is a incident-by-incident question that would have to be reviewed. I can't give you a general answer for it because of the underlying question, not being able to control who posted the picture or information or whatever on social media. But it's a little iffy. You have to be careful.
Two things. Getting back to that whole taking of risk in advertising an event.
Underwriting.
I know that K-Love has cruises, and the way they do it is they rent out the whole cruise ship. So they took on all the risk. They just go to whoever, they're going to buy your whole cruise ship for $1 million or whatever, and then they go around and sell those spots. If they don't fill it up, then they lost money. I'm sure they always fill it up, so it's not much of a risk for them. This just ties back into the earlier discussion about sponsorship, who's taking the risk. But I had another idea. I have never done this yet, but we have a dentist on the radio station. We used to have an attorney, and I've been thinking about having a 1-minute spot like your oral hygiene tip of the day, why you should floss your teeth, brush your teeth, or whatever, and at the end of it say this was sponsored by or brought to you by dentist so-and-so. Or if it was a lawyer, it could be, you know, why you should have a will if you have young children or something. Just like a tip of the day, a legal minute, a dental minute, or whatever, with a clip at the end saying brought to you by so-and-so, and then that business would pay you for that. Is that something you'd view as legal?
I would view it as legal as long as the identification of the sponsor was, you know,
Neutral.
plain generic name, rank, and serial number.
Not promotion.
Not promotional,
Really neutral.
yeah. Okay,
Hi there. I was just wondering if you guys have heard anything about the C4 class developments. Is that coming along, going to happen, not going to happen? And what are the legal implications of that, either way?
I'm going to have to.
okay,
that one, sorry.
C4 has not, it is not an explosive, although some engineers that have commented, you would thought it was. It seems to have lost steam. That the commission, I believe, I don't remember if we're at the NPRM stage or just the notice of proposal or the petition for rulemaking stage, but it seems to have lost steam, and we've not seen much action from it, and there doesn't seem to be a real campaign to add that. But let me give a quick background for what the C4 would be. It would be, right now, the maximum power for a Class A FM is 6 kilowatts. And the idea, and the minimum, the minimum for a Class C3 is 6 kilowatts too, but the normal C3 would be, a maximum would be 25 kilowatts. The idea would to put another class in between, that it would be C4 with a maximum ERP of 12 kilowatts, if I remember, or 12.5, but right in between the two. The idea is being that some Class A's would be able to increase their power to get a little more range. It was brought forth, the commission certainly put it out for the petition for rulemaking, out for comment. I don't recall if they put out the notice of proposed rulemaking, but it doesn't seem to be actively pursued right now. Now watch this, the next thing we know will come out in tomorrow's releases. Go ahead.
About the C4 is it's almost meaningless in the terms of a non-com, because you could run a 10 kilowatt class B or C. It doesn't have to be 25, and you don't have spacing rules.
Exactly.
So it's not a good thing for us.
Right. Just to continue what Bob's saying, and I'm sorry, you go ahead, Bob.
It's a big thing for commercial channels, but not for us.
Right. Just to quickly, for people in the non-reserve band, that is 92.1 to 107.9. Those are allotments, and they're classified. A in the East Coast and California, or Northeast and California. B, B1, B2. Is there a B2? I can't remember. And then in other parts of the country, it's C's. C, the full C is the big flamethrowers. C1 has got a height limitation, still 100 kilowatts. C2, you think it's 50 kilowatts, and C3, 25 kilowatts. And the spacing is fixed between these, I don't want to go into all the engineering, and Bob could tell you much better than I, but the spacing is fixed. In the non-commercial portion of the band, 88.1 to 91.9, it's what's called a demand system. And you basically choose the power and height that will fit for you. And therefore, while they technically have classes, it's not a big deal for the non-coms.
I had a question about songs.
Yeah.
That are played, because songs now are embedded with a lot of information. Sometimes someone might give you a song, they might gift you some songs. You're not
Right.
sure where it came from. It may not have embedded information. But any song can be played as far as
Well, you
on your-
segued right into what we wanted to talk about,
Sorry.
music licensing. You have to have for your over-the-air broadcast, you have to have a license for the composition, the underlying notes and words. And typically, those come from ASCAP, BMI, and CSAC. And if you don't, you really need all three. You really need all three, because you can't be certain, because people jump from place to place. And like I say, this is a music, if you don't have it yet, for some reason ASCAP has not come to visit, BMI has not come to visit, that's
They will.
surprising, first of all.
They will.
But they will. You need to have music licensing for those. The fees that you pay for that music licensing are fixed based on the population within your 60 dBU contour. And there's adopted into rules adopted by the Copyright Royalty Board for non-commercial stations. Commercial stations is a different thing, but for non-commercial stations, they're fixed into the statutes, or more precisely, rules. And you can, ASCAP and BMI will be happy to tell you what your fee is, and it's an annual fee. They run from a low of about $687 per organization for ASCAP and BMI. They're the same thing. CSAC's about a quarter of that. It goes from $687 per year to about $6,000 per year for somebody that's got a real flamethrower. There's a lower price, by the way, if the station is primarily a talk station. Now, that covers your over-the-air broadcast. Go ahead.
That was a perfect segue, actually, because I had a question about music licenses. So there's a music license that you would pick up through ASCAP or BMI for what you broadcast over the air.
Correct.
But when people call into your station and you have music on hold, and maybe I'm going outside the lines here a little bit, but does that license for over-the-air routinely cover things like music on hold or overhead music in a public space?
Do you know that?
I'm not 100% certain, but I believe the answer to that is no. There is a different kind of license that you can get to cover that, but it's not covered in your over-the-air broadcast.
One of our partners, Karen Ablin, is just a whiz in this stuff.
She's an expert.
Send us an email and we'll get you the answer on that.
Yeah.
Christian copyright licensing, CCLI, covers your church usage, and that's overheads in church, song sheets and things, and they have an option. CCLI has an option for an added cost that covers music on hold and also playing music before and after your services. So if you play a CD in your church service before the service begins, that's a public performance of a copyrighted work. It's not permitted. If you play the radio in your church before church begins, that's a public performance of a copyrighted work. It's not permitted. Your license to broadcast over the radio covers personal use at the other end. So if somebody is playing the radio in a public place, and BMI has people that'll go around, they'll go to a restaurant, sit down, have a bite to eat, and make a note of what they're playing in there and make sure they have a license. You just can't play the radio in a public place. That's a public performance of a copyrighted work. So Christian copyright licensing, which we probably all have for our churches, that covers song sheets and projected words. And for an optional cost, they'll give you a license that lets you play music before service, after service, and also music on hold. And they also have a video option. So if you play videos in your Sunday school for the kids to watch or whatever, they have an option that covers that also. You know, everybody's hand is in the pie, and they all want a piece of your action.
So we've kind of run out of the time. One of the things, though, is how many of you are streaming? Okay. If you have, since we've run out of time, if you want to talk about any streaming issues that come up and dealing with sound exchange, let me know. We can be around for a little while. We do have to catch a train, but we can be around for a little while. I will say it can be complicated, but in most cases, most of the stations are going to be below the minimum threshold or the threshold that you pay only the minimum fee, which is 159,140 aggregate tuning hours per month, which was an average of 218 people at any given, or an average over the 24-hour period of 218 listeners. It's a complicated, it can be a complicated process, but it is an essential process. If you stream music, you need to have a sound exchange license. And I've had clients tell me that seems like a lot of bunkum to them, and that these are really, it's baloney. It's not baloney. They are a legitimate organization, and you do need to get it squared away, because the auditing costs, if they come after you, it's just not worth the hassle.
I wanted to make one other comment, and that's regarding GMR, which is another music licensing group that has sprung up in the last few years. And let me limit my comments to this. As a general rule, their catalog does not include Christian or religious music, so it's unlikely that you would need to have a license with them, but they press pretty hard. They've backed off quite a bit on non-coms. But, you know, if you have questions about GMR and whether or not you need to have a license with them, we can put you in touch with Karen Ablin in our office, who is a whiz-bang on those issues.
Thank you, guys. Let's give them a round of applause. Thank you. So 15 minutes. Please be back here at 11:30, where Brad Dacus from the Pacific Justice Institute will be, and then Bob Moore will also have his computer. Thank you, guys.